Well, good afternoon. I wish I was going to say it's so nice to see all of you, but I can't actually see you. But I'm glad that you decided to participate. It's a 2-hour session. So if you have questions, please feel free to put them in the chat. Don't feel like you have to wait to the end. It's actually easier for me to answer a question when you're answering a question about what I just said rather than try to remember from 90 minutes ago what it was I was talking about. Also, feel free to interrupt me if I use jargon you don't understand. Social Security is a very jargon heavy practice, and I have tried to define the terms that I use in the PowerPoint, but I may use terms that you don't know what I mean. So feel free to tell me that you don't know what SGA, which is substantial gainful activity, and RFC, residual functional capacity, or terms like that. If you don't know what I'm saying, please put it in the chat and I can quickly answer those questions. Or if you have suggestions, these are suggestions that I'm making in terms of how to practice, but I'm sure those of you who have been practicing for a long time may have other suggestions. And those of you who haven't been doing this kind of practice may have insights that you want to share, or strategies that you've used in other areas that you have questions about whether that'll work in a Social Security practice. So again, don't feel that you can't ask questions. I would normally be looking around the room and seeing if you raised your hand or indicated that you were confused. So please feel free to do that. All right, so I'm going to talk about Social Security handling, starting with intake, the initial interview, and then going through the hearing. The focus will be the ethical requirements. Part of the reason we need to talk a lot about ethical requirements in Social Security practice is the ethical requirements are different for Social Security than they are in your general practice. So something you might do or not do in your regular litigation, like doing a custody case, is not the same in all instances as what you would do in a Social Security case. And I will point those things out as we go along. So I'm going to get started without further ado. Except that my PowerPoint is frozen. Kelly, do I have, it says I'm screen, there it is. Okay. Just took a minute to get it. Okay, so the rules of conduct and standards of responsibility are contained in these two places: 20 CFR 404-1740 and 416-1540. You will see throughout that I reference both a 404 section and a 416 section. 404 are the regulations that relate to Social Security disability benefits based on your earnings record, known as Title II, and 416 is SSI. With respect to the disability process and the rules that apply to disability, they're the same for Title II and Title 16 SSI, but they appear in parallel citations. So that's why you're going to see those parallel citations throughout. SSR refers to Social Security ruling. Social Security has rulings which are below regulations in terms of source of law, but they are used certainly by ALJs. And there is case law, even at the district court level, that since Social Security relies on them, and that they have the force and effective law. So certainly that SSRs are something that you have to follow. The SSRs, generally speaking, are based on regulations anyway, but often provide more detail. All right, so in Social Security, you have some affirmative duties. The first affirmative duty is to act with reasonable promptness to get the information that you need and send it to Social Security. So what's reasonable promptness? Social Security hearings are held, they send a notice, and generally speaking, they have to give 75-day notice of the hearing. It is not reasonable for you to wait until 5 days before the hearing, although you can because that's your deadline, but it's not reasonable to wait until 5 days before the deadline and send 2,000 pages of medical records. At the earlier stages, if you're helping at doing a reconsideration stage, again, you need to send the evidence when you get it. You need to request it promptly and send it promptly. One of the reasons you need to do that is for your client, because the sooner Social Security has the great evidence that you're getting, the sooner they're hopefully going to rule in your client's favor. It also relieves Social Security of having to obtain the evidence themselves, which they don't want to do. They want you to do it. So that's an affirmative duty. It's not something you can wait to the last minute like you can in some other practices. The other thing you have to do is assist in getting evidence from the medical sources and regarding work experience, daily activities, efforts to work, and other factors. Medical sources, you're going to send out to all their medical providers and request the records. And that actually is often a difficult process. You make a request, you make a second request, you call, once a week, then you call once a day, then you send your client with the authorization to go pick it up. That it can take a long time to get medical records, despite the fact that clients are entitled to get them. So you need to start early enough that you can get those records so that you have them and can provide them to Social Security and help your client by getting those records. Work experience, clients are often very confused about what their work history is. It makes a difference in Social Security because one of the steps is, can you do your prior work? Well, the first question is, well, what is your prior work? And if you ask the average person, honestly, including myself, what was the date that you stopped working at your previous, your 3 jobs ago? People have a hard time knowing what that is. It makes a difference because prior relevant work only goes back 15 years. So you're going to need to get information about what that is. Now, Social Security will have that for you once you get to the hearing stage. You'll be able to look in the electronic record system and see what their work record is. And then you'll be asking clients what that is, because a lot of times the person or entity that's listed is not who they know the company to be, because a lot of times payroll comes out of some other place, like in Florida, and doesn't say who it actually is. Daily activities are really important in terms of showing the impact of people's impairments on their daily lives. Those are questions you're going to be asking the clients about and getting additional evidence about. Efforts to work. It's helpful if you show that your client has tried to work and can't. They had a job and then they started working part-time and they couldn't even do the part-time work. So then they tried another job and their impairments prevented them from being able to work. It shows effort on their part, which Social Security likes. So if you have a client that came to you and they've tried to work, you certainly want to indicate that and develop the fact that it was an unsuccessful work attempt, if that's what it was. You have to be very careful, though, about telling clients to work, because they definitely can't make more than substantial gainful activity. And we'll talk about that because that'll knock them out right away. Then, as I said, provide competent representation, and that includes doing the things we just talked about. Withdrawal. Again, this is different in terms of the difficulty of it than other areas of practice. Once you have sent in your 1696, and your 1696 is your appointment of representative form, which is what tells the Social Security Administration that you're representing the person. You send that to the local office. Once you've done that and you're entered as the attorney, you can't just quit when you realize that your client has no case, especially if the hearing has already been scheduled. And that's what it says here. You should not withdraw after the hearing is scheduled unless you can show there's extraordinary circumstances. Now, they look at it on a case-by-case basis. Extraordinary circumstances might be, you get your 75-day notice and you've been trying to get a hold of your client for the last 2 months, but they've fallen off the face of the earth. This is not that uncommon with our clients. You've done everything you could to find out where they are. You've sent letters, you've contacted relatives, you've done everything you could think of to get a hold of the client. You haven't been able to get a hold of them, and you're asking to withdraw. Even that type of request to withdraw should be done right away. You shouldn't wait till 5 days before the hearing or a week before the hearing and say, well, I looked for him the last 2 months and I couldn't find him, and now I'm going to withdraw. Social Security has the obligation to help the clients develop the record, and they certainly want to know if you're not going to be developing it, they need to. So don't wait to the last minute to do that. And the ALJ can refuse. The ALJ can say, nope, you can't. You're going to stay in. I don't care what your problems are. In fact, I'll give you an example of that. I was 9 months pregnant. actually not quite 9 months pregnant. I was pregnant and my doctor said, stop working, because every time I went to work, I went into labor. So I called Social Security and said, I need to stop working. And they said, no, I mean, I need to stop working. And therefore I need to have these hearings postponed. And their answer to that is, no, you can't do that. You're going to have to come. And and I had to argue quite a bit to convince them that should be able to withdraw and that the case should be postponed. So again, withdraw promptly, which again means you have to go ahead and ask for the records far enough in advance so that you can review them. So if you review them and think, well, really, I have no case here, you have a chance to withdraw before the hearing is scheduled. And also to give the client a chance to get another attorney. If you're not going to do it, you want to give them a chance to get somebody else to do it. And somebody else is going to want to do it either if the hearing's coming up quickly. So things you have to tell Social Security. You have to tell them if you ask for a medical or vocational opinion. So if you write to the doctor and say, please fill out this medical source statement for me, please answer these series of interrogatories, please write me a letter and say that my client has this particular disorder, or that she's terminal, or that anything you ask, and the doctor provides that evidence to you and you provide it, or the doctor provides it directly to Social Security. If you have solicited that opinion, you need to affirmatively tell the Social Security Administration about that. And that also includes vocational evidence. It applies to a formal medical source statement. It applies to if you contact the doctor and talk to the doctor, which is about impossible anymore to get a doctor on the phone. But if it's possible for you to get a doctor on the phone, and talk to the doctor about what's going on, and they tell you, and you say, that's great, could you write a letter that says that? And they say, no, I absolutely do not have time to write a letter that says that, but if you want to write a letter that says that, I'll sign it. If you do that, you have to tell Social Security that you've done that. Now, that's a dangerous thing to do, in the sense that ALJs tend to look at those kind of documents that attorneys or other advocates draft suspiciously. So you want to be very careful. That wouldn't be your first thing that you would do. You might tell the doctor, well, how about I send you some interrogatories? Because the judges would very much prefer to see some handwriting on something, or some typed responses by a doctor, as opposed to something that you drafted. All right. Suggestions about the need for treatment. So your client comes into you and says, I have intractable back pain that causes me to use a cane, and I spend the majority of my time in bed. And in addition to that, I have hallucinations every day. And you say, oh, okay, well, what treatment are you getting for that? And they say, I'm not getting any treatment. I don't like doctors. The likelihood that you're going to be successful in a case where your client is not getting treatment is slim, extremely slim. Social Security may send a client to a consultative exam to try to develop some evidence. But generally speaking, if a client is not getting treatment, it's going to be very difficult for them to be successful in their claim. So what you want to say to them is, well, if you have intractable back pain, then you ought to get treatment for that. And the reason you ought to get treatment for that is maybe it'll make you better. Maybe you'll feel better. And the second reason for that is, if you don't get treatment, then Social Security is not going to grant your claim for benefits, because as far as Social Security is concerned, if you're not getting treatment, then you don't have back pain. And if you're not getting mental health treatment, then you don't have hallucinations, because obviously neither one of these problems are not serious enough for you to even think that you need to get treatment. So suggesting treatment is a good idea, but if you do that, then you need to tell Social Security you've done that. Now you see here it says, it refers to if you're going to do that, suggest treatment by, or the assistance of, the individual providing opinion evidence. So in all likelihood, there's going to be, even if all you do is tell somebody to go down to the local mental health provider or some mental health provider and get treatment, and they do that, there's going to be there may be opinion evidence just in the treatment notes. You may decide to send them a medical source statement, and that definitely is going to be opinion evidence if it indicates limitations on what the client can do. So the easiest thing to do is if you suggest that somebody get treatment in your efforts letter, which you have to send to Social Security, just say, I suggested they get treatment. When they came to my office initially, I suggested they get treatment for their impairments. Simple thing to comply with if you just do it. Unethical not to. So it's one of those things that you don't necessarily think of at the time. I usually do, if I suggest treatment, which I always do for a client who's not getting treatment, as soon as I suggest it, I tell Social Security. That way I don't run the risk of forgetting that I did that, because these cases can go on for years. So you don't want to, it's easier to just do something than try to remember to do it, especially if it's a simple thing and you're at the point where you can, where you're going to make that disclosure. Things you can't do. Now, these are things that are common to all practice of law. You can't provide false or misleading statements or evidence. Now, sometimes you're tempted to, in a case that you're doing for Social Security, and you have a record that's 2,000 or 3,000 pages long, to just mention the things that support your client and don't say anything at all about the things that are a problem. If you do that in such a way that you're being misleading, then that is a prohibited action. The better practice and the ethical practice and the required practice under these rules is you're going to want to say something about the negative evidence and explain why it doesn't make any difference. Yes, there was an MRI that showed that he didn't have significant arthritic changes at that point, but that was 10 years ago. Yes, he had told his therapist that he had a record for DUI, but that was 20 years ago. So you do like you would in all kinds of litigation in many ways. You take your strong points and lead with them, and you deal with your negative points. In Social Security, though, it's not just a matter of strategy. It's a matter of you have to not do anything that could be construed as false or misleading. And the other reason is Social Security, if you practice, say, in the Harrisburg office or in the Reading office, a lot of times you're going to appear in front of the same judges. So you want them to trust you. You want them, if you say to them, there's an MRI, and it was, the MRI was last year in June, and turns out there is no MRI. It's actually an X-ray and you forgot, or or there was supposed to be an MRI and there wasn't. You want to make sure that what you're saying is true. And usually when you're saying something to the judge, you want to have a citation in the record by exhibit and page. If you say there's an MRI last year that shows disc and degenerative changes and narrowing of the spinal canal, and the nerve root was changes anyway. We don't have to go into what the changes are, but anyway, you see changes on the MRI. You want to be able to say that's exhibit 13, page 4, so the judge can easily find that.
Becky?
The other thing, yes.
Sorry, we have a few questions.
Okay, great.
If you ask the doctor and they refuse to fill out any forms, do you have to tell ALJ that?
I usually do, and I have a sample form. I don't know if you've had a chance to look at the materials. I usually do a generic, here are the providers, and I have requested that they complete medical source statements. And so it covers everybody. If I've requested that a medical source statement from a particular provider, I think the safer thing today to do is to make sure that you say that. And when you say it in a kind of a general statement where like I do that for everybody, it doesn't have the negative connotation that you might think that it would have.
Okay. Next question is, are the disclosures only at the hearing stage, or if you're helping the individual with the initial application as well?
Now they're all there's nothing that says that this doesn't apply all the way along. Now, the initial application stage, you might not be gathering information in the same way that you are, but you're the attorney, you're supposed to be helping. So you're supposed to be helping. I don't know if any of the other experienced practitioners on this call have any other thoughts on that. Honestly, I don't help people fill out applications all that often.
Becky, we have another question. How do you make
Okay.
these disclosures to SSA? Written letter describing actions you took, phone call?
Oh, definitely written letter. Written letter submitted through the through the electronic record system. And the materials I gave you a sample written letter, where what you do in your efforts letter is you list the providers, the dates, and the contact information, the address, fax if you have it, approximate dates of treatment because your client's never going to be accurate completely about when the treatments are, and then you put your disclosures in there. And then you send that letter to the Social Security Administration at the recon level and at the, I mean, there's access to the electronic record through the electronic record if you can do it that way, which you should do it that way if it's possible. Other questions?
Yes. I have similar questions about the timing of disclosure. We routinely encourage our clients to get treatment and abide by their providers.
Treatment recommendation, you mean? Yeah, that's a good strategy. So your question is, when do I have to say that you've recommended treatment? Well, I would say certainly no later than the 5-day deadline before the ALJ hearing, but normally I would recommend sending your efforts letter prior to then. So I would send it along with, here's all the providers, and I've suggested that they obtain the treatment, kind of just as a general, like.
Sarah Lynch just made that comment. We also use the inform letter to make disclosures at the initial and recon levels. We send it in with the barcode provided. So that's all the questions for now.
Okay, that's great. And again, these are obligations that you have. You don't, it's just easier to do. I mean, you're required to do them. It's easy. It's easy to do them because it's required. You're required to do them. So, yeah. And if you don't have the ARE yet, you can use a barcode, and I'll show you what a barcode looks like in a minute. It looks like what you think it looks like. You can't unreasonably delay the case. So this comes up in continuing disability reviews. You can get disability benefits, and then Social Security can decide they're going to review your case to see if you're still disabled. They're called CDRs, continuing disability reviews. So you may get a hearing in a continuing disability review, and the client may be getting ongoing benefits because they've requested them within the time period required, which is a short time period when you can request ongoing benefits. And you have a hearing scheduled and you have some evidence, and the client kind of doesn't want to go to the hearing, and you think, well, maybe we should just try to delay this case. Maybe we should just not go. Maybe we should find some reason to try to get this case delayed so that they can keep getting benefits. That would be a problem if the only reason you're doing it is to delay the case. So the other way you don't want to delay the case, and this is the thing that makes judges mad, and makes it less likely that you're going to get a positive result in reconsideration, is if you don't get the evidence, when you don't make your reasonable efforts to get the evidence, and then you come up to the hearing and you say, well, I requested records from the neurologist and the primary care provider, but I haven't gotten those records yet. So I need to have the record kept open for an additional 30 days for me to get the records. Social Security hates that. Judges hate that. I have actually heard judges rail against that. It means they have to keep the file open, and that messes with their stats, which makes them mad. It's an after action thing, so that they can't finish what they're doing, which makes them mad. And they're mad at you because you were supposed to ask for those PCP and neurologist records in time that you would have them. So it's delaying the case by not requesting the records in a timely fashion is something that's prohibited. Using threatening or intimidating language, you would think that people wouldn't do that, but of course, sometimes in the Court of Common Pleas, I have seen attorneys who think that acting in intimidating ways is an effective way to act, but yeah, I don't think it is there, and it's certainly not here. You're threatening some assistant at at the ALJ level, if they don't hurry up and move along the case, you're going to do this, that, or the other. That is not going to it's not going to make the case go faster. It's probably going to make them stick it in the get to it when I couldn't, when I feel like it pile. So you're, cajoling, saying you're going to do things that you can do. And a lot of times, if you say you're going to do, the thing you're going to do is, here's how I'm going to help make this easier. Here's how I'm going to make the judge's job easier. I'm going to get all the evidence that I can get. I'm going to I'm going to request a subpoena if I need to. I'm going to do everything so that the judge doesn't have to do any development of the case. And I'm going to hand it to him on a platter, including my pre-hearing letter brief memo. And all you have to do is just show up and, read the file, listen to what I have to say, and you're good. That's good advocacy. Threatening and intimidating is not. And it's specifically prohibited. You can't just rely on your assistants. Actually, people I have known who have been disbarred from the practice of law have often, and not that I know that many of them, I know a handful, and I've been practicing law for a really long time. Often it's the people that work for them. You cannot say, oh, well, I didn't do that. My paralegal forgot to send in the evidence. My paralegal didn't send in the efforts letter. She can do that, but she just forgot to do it. I heard an attorney one time have to, in a hearing, I used to do appellate briefs exclusively, try to explain why all their 5-day letters were late, because the paralegal didn't understand how to calculate 5 days. It's 5 business days, and they had used 5 calendar days. Not a good thing. That's a prohibited action. You have to make sure not only that you know what you're doing, but that your assistants know what they're doing. Now, the example I just gave you was not somebody who was disbarred, but people who have like missed the statute of limitations or done, I mean, a lot of times they're like, well, that's kept by my paralegal, not an excuse. Or people that you contract with, not an excuse. You can't have a large Social Security practice and contract with an attorney to do it, and they go to the hearing and screw things up, and you say, well, it's not my fault they did it. You've got to make sure people in your office know what they're doing. And that's true, general rules of professional conduct too. Okay, this is examples of referrals to the Office of General Counsel. They're going to kick you off. You're going to make it impossible for you to do Social Security practice, or maybe they're going to criminally prosecute you, is if you don't do the things you're supposed to do. You don't get the evidence. You don't tell us about the evidence. Instead of telling us about the evidence, you wait 5 days before the hearing and say, hey, here's a list of 25 providers. I think they have evidence that would be relevant to the case. Did I submit any of it? No. Did I request any of it? No, but I'm telling you about it. That is not something that you should be doing. Now, if you've done all the things you can possibly do to get the evidence, that's something you are going to put in your efforts letter. And that way, if you have to ask for a subpoena, the judge may be likely to give you a subpoena, or the judge may be likely to keep the record open for a couple of weeks or a month to get that evidence if you've done everything you can do to get it. The MRI that happened, 4 days before the hearing, that's obviously you can't get that 5 days before the hearing. So that's the kind of thing you can do. If you have a pattern of doing that, if you're the kind of attorney that always waits to the last minute to do it, then they're going to do a referral, try to get you in trouble and try to kick you off of the practice of Social Security practice. So best practices. So I give you a link here. They have a section on best practice at ssa.gov. You can go look at it yourself. A couple of the things that they specifically say is they want you to use the electronic records express, the ERE. They do not want you to send duplicates. They hate duplicates. I hate duplicates. When I read, I hate duplicates when I'm reading through a file to write a brief, because they keep, it makes it hard to read the file. It's hard to separate out duplicates, but you can use your PDF tools function to take a 300-page document and extract the pages that are duplicates. And you've been taking notes, so you know what the duplicates are. Because they don't want, the records are long enough, and they don't want you to submit the same thing over and over again. Now, I will say the one area where it's difficult sometimes is if you get printouts from electronic record medical systems, like from Penn or from the big medical systems, Tower Health. Like sometimes they'll send you records and then you ask for them again. You say, give me updates from this date. And they don't give you updates. They just give you the same thing all over again. But they select different fields, even though you've asked for all of it. And then in the different fields, this time you got a bunch of stuff with nursing notes sprinkled in, or with the physical therapy records, or with, so if it's not this, if it's not duplicates, go ahead and send it. You don't have to pull out every single, if you read medical records, you can see that, especially these electronic medical record system now, the history and physical, for example, might show up 5 times in the record. You don't have to go through and take out every history and physical. But what you don't want to do is take the ER record for a particular date and submit that whole thing again. You don't have to go through and take out the because it's really hard to do that, and it's hard to pull out just the part you want to pull out. But in general, try to not submit duplicates, because it makes them mad. And it makes it harder for them to see the good evidence that you've got. You submit one SSA 1696, which is the appointment of representative form, one per representative. You can't say Mid-Penn Legal Services. You can't say Community Legal Services. You have to say you, Rebecca S. Dempsey. And I don't know if I think I gave you that form, maybe not. Anyway, it's at ssa.gov/forms is where you can find the 1696. Okay, initial contact with the client. So the first thing you do, if you have them on the phone, if you have a paralegal or is the first person that speaks to them, whoever, initial contact with the client, the very first thing you have to do after you figure out that it's an SSI or disability insurance benefits DIB case is you say, what stage are you? What is the last notice you got? Okay, so I got a denial. I requested reconsideration, and the reconsideration was denied. What is the date of that notice? And then, have you appealed? Have you requested a hearing? Or if it's the initial stage and I've just been denied my initial request, did you request reconsideration? If they haven't already done that, you need to explain to them how to do it. They can do it online, or they can use the paper forms. The request for reconsideration, the request for a hearing. I can give you the forms there, again, available at ssa.gov. The requests for reconsideration and hearings, go to the local office, the local field office. You can look up the fax numbers of the local field office at ssa.gov. In the old days, the client could just walk down to the local office. And actually, this is a problem for clients. A lot of my clients over the years, they don't know how to figure out they can't figure out what form it is, or how to figure it, how to fill it out, or what to do. A lot of them are illiterate, or maybe they're Spanish speaking, or it's just too hard for them to do. So they would just go to the local office, and the local office would help them fill that out. Now you can't just swing by the local office because of COVID. So a lot of people are having trouble meeting the appeal deadlines. But it's your duty, once you have a contact with that client, it's your duty to make sure that they're going to, even if all you're going to do, even if the extent of your assistance is, I'm telling you what the appeal deadline is, I'm telling you how to do it, I'm not telling you I'm going to do the case, or I'm telling you I'm definitely not going to do the case after talking to you, but I'm at least telling you what you need to do that. The one thing you don't want to do is have a client that you talk to, or one of your staff talks to, and then you finally, you get to meet them and you say to them, okay, so now, let's review the notices, and you read me the most recent notice that you got, and you tell me what's happening. You realize that the appeal deadline is passed. Once you have that initial contact with the client, then as far as they're concerned, you're representing them. Even if you haven't explicitly said that. So you either want to make it very clear, I am not representing you, I am just talking to you. But even then, I would say, tell people that they have to appeal. That is right on our screening sheet for what anybody who talks to Social Security clients is to say, is go ahead and appeal. Don't wait for me. The request for reconsideration, all you need to say is, I am disabled. Request for hearing, I am disabled. You don't have to give a big long explanation. I am disabled and unable to work, but I am disabled is good enough. You don't have to do a big long thing. But for some of our clients, even that's too hard to do. So you definitely don't want to miss appeal deadlines. You certainly don't want to miss it if you're representing the client. And you don't want it to get all murky in the like, oh, there's just an intake, so I haven't, we kind of didn't tell them what to, you don't want people to miss their appeal deadlines, because otherwise then they have to go back and start again. They have to go the beginning of the shoot, and that'll take a while, and they'll lose benefits. You can request to reopen a prior application, but there's specific requirements that apply, and so you definitely want to make sure that you do that. So the rules, they're the same rules I've been citing all along, are in CFR. And also there are general rules of professional conduct 1.3 and 1.1, diligence and promptness, competence. Diligence and promptness 1.3, they talk about specifically missing statutes of limitations, missing the deadlines. So important initial thing. So the initial interview, you want to explain the sequential analysis. Now, I don't know, and normally this is the time when I would say, how many of you went to Kristen's training on Tuesday? So you already heard about the sequential analysis. The sequential analysis is just how Social Security decides Social Security cases. So, and I'll talk a little bit more about it. I have a slide that talks about that, but it's just, are you engaging in substantial gainful activity? Are you, do you have a severe impairment? Anyway, I have a slide that talks about it, so we'll get to that, but you ought to explain that. Also explain the difference between SSI and disability insurance benefits. Title II, SSI is you can get if you're age blind or disabled, whether you've ever worked a day in your life. Disability insurance is based on your earnings record, and you have to have the required number of quarters in order to get disability insurance benefits. A lot of clients don't understand the difference and don't understand what difference it makes in terms of, like, disability insurance benefits has a 5-month waiting period and SSI doesn't, but SSI starts from the date of the application. So there's lots of little things that affect it, but you just want to give the clients a general idea of what it is. So initial interview questions, you want to get a list of all the names of the people that they see, and be prepared for the fact that it's probably going to be incomplete. When you say, who are all your medical providers? I often ask them to do this list before they talk to me. Some of them can access their medical records through a patient portal and try to get this information. It's a lot of times it can be easier for some of the more literate clients to try to do this, sit down and think about, okay, I'm going to write these down. I'm going to get the dates of treatment. But often they forget to tell you about something. So you're going to ask it at the initial interview, but you're going to keep asking it during the course of representation, because a lot of times they're just not going to, they're going to forget. Oh, did I forget to mention that I had a neurologist? Yes, you did. Did I forget to tell you that I had an MRI or I was in the hospital last week? Yes, you did. So you need to ask, because the clients are under a lot of stress. Medications, it's easiest, again, if they can look, if they have a piece of paper to look at when they do that. Now doctors' offices are actually pretty good about, when you go to the doctor, they give you a piece of paper that says this is what happened and this is the medicines you're supposed to take. You can ask your clients to pull out one of those and tell you about those. Also, the medications are often a clue as to what's wrong. A lot of my clients over the years who have very serious mental health problems will tell me that they're disabled because they have back problems. But then I find out they're taking Seroquel. Seroquel is an antipsychotic. So if your client is taking an antipsychotic, there's probably a reason for that other than that they have back pain. And it can be a way to slide into, like, so you're taking this medicine. Well, what are you taking this medicine for? Oh, well, that's anxiety. Okay, so tell me about the anxiety. It's kind of a way to back into it, because a lot of people, there's still stigma attached to mental health issues. And a lot of people don't want to admit to that. It's okay for them to be disabled because they have back pain. They don't want to say they're disabled because they have mental health issues, even though a lot of times the mental health issues end up being more severe than the back pain in terms of limiting their ability to work. Work history, talked a little bit about that. You want to see what their work history is. One of the things you can argue is if you have a client with a good work history, that's a factor in their favor. On the other hand, if you have a client who's never been able to work because they have a low IQ and they have physical impairments as well, then that's something you want to know too. You also want to know why. Like, have you tried? Did you ever try? What happened when you tried? Education. The education records can be helpful if they can include an IQ. Special education records can include specific information about limitations. Education records can be hard to get for somebody who's an adult now. Now, if you're doing a kid case, you can usually get those records pretty easily if they're still in school. But you want to try to get those education records if you can, because a lot of times for our clients with learning disabilities, the kinds of things that might affect the type of work that they can do, that'll show up in their education records. Then there's a statement of ask the client if they know what diagnoses that they have and what their symptoms are. You want to try to quantify the symptoms, like, okay, I have panic attacks. How often do you have panic attacks? Once a year? Once a month? Every other day? Give me how often does this happen? What causes it? Is there anything you do to relieve it? Is there anything that brings it on? Those types of questions to get a sense of like how serious that symptom is. I have migraine headaches. Well, how often do you have migraine headaches? Well, I had 2 last year. Well, then this isn't something that's probably going to be a big deal. I have migraine headaches every day. Well, and that's something else. So you want to find that out. Activities of daily living. How do you spend your day? What time do you get up? What do you do? Do you do your own cooking? Do you spend all day in bed? What do you do? Get a sense of the client's, what's going on with the client. Initial advice. Okay.
Sorry, we have a question.
Okay.
Are you talking about submitting only one 1696 when in the appeals process using the electronic record? I've had to fax several 1696s for one client during COVID because of lack of access to certain files by SSA reps. This is for mostly non-disability issues. Is it problematic submitting more than one 1696 in that instance, not to the electronic record, but faxed to SSA reps?
Oh, no, you can send as many. I mean, if it's the same 1696, you can send as many as you want. I mean, I don't think that's, although if people are saying, I don't have your 1696, it ought to be in the record. If you get the NOSCR form, they just talked today about issues with the appointment of rep form actually being, I forget the term that the field office rep gave me, but they're supposed to propagate it, I guess. They're supposed to send it where it needs to go. And that often doesn't happen. So you send your 1696, but you still can't access the ERE because they haven't pressed the right button yet. So no, I don't see any reason with, I mean, I've sent 1696s repeatedly sometimes because it's not, they ought to be able to see it. Anybody in Social Security ought to be able to see it, but they might not be able to. So no, I don't see a problem with that.
Thank you.
Any other questions at this point?
Actually, there's not any other questions.
Okay.
Right now.
All right. Okay. So compliance, we already talked about suggesting treatment and suggesting providers and your obligations there. The need for compliance with treatment recommendations. Social Security has specific rules about that I cite here. The basic rule is if your doctor tells you to take a pill, you need to take it. You can't just say, I have high blood pressure that is disabling to me and it makes me dizzy. Well, what did the doctor recommend? The doctor said take a pill, but I don't like pills because I don't want to take pills. I feel like it's better not to take pills. That is not going to fly. You need to follow reasonable treatment recommendations. Now, risky surgery is a different category. But generally speaking, if your doctor says you need to get physical therapy, you need to get physical therapy. And if you don't do that, that's going to be used against you. If your doctor says you need to go and see a therapist, in addition to seeing a psychiatrist, then you need to do that, and you need to do it. You need to do it consistently, not miss every other appointment. I have seen repeated opinions where the judges say, well, obviously this is not that big a deal because the client doesn't go to her treatment. She, here's a bunch of no show. You need to explain to the client right away, don't do that. And right away, tell me when you go somewhere. If you get if something else happens and they recommend a neurologist, then go to your neurologist. Tell me so I can tell Social Security. So here's the 1696. One question is, should you send it in right after the interview or after you review the medical records? If you're going to send it in after the interview because you're so convinced by the client's, just the information you have at the interview, then great. And then you have to stay in and not withdraw like we talked about. Um, if you wait until after review of the medical records because you the client's symptoms and you think, oh, I don't know if this case is, I don't know if this is something I'm going to take, then the safest thing to do is a retainer that reflects the scope of your representation. I am going to obtain records and determine if I'm going to be able to assist you. Or I am going to represent you at reconsideration, but not beyond that without further evaluation. I'm going to represent you at the ALJ hearing. That's all I'm going to do, because you want to be able to say, I'm not going to do an appeals counsel brief because I don't think it's warranted at this point, or I don't have time to do it, or whatever the reason is. Make sure you and the client are on the same page about what you're doing. And you send it to the local office, you indicate which type of cases you're doing, and if you're legal services, you waive the fee right on the form. Didn't used to be on the form, but they just put it on recently. Okay, now gathering and submitting evidence, I've been talking about that, so you have to do it. It's not sufficient, in my opinion, to tell the client to go to the patient portal and get the information. And the reason I say that is because patient portals can contain incomplete information. They do not have all the notes. They have some of the notes, whatever the provider has decided that patients should have. So it's better now. If you can do patient portals work great for things like getting an MRI, because an MRI is an MRI. I mean, it's not, they're going to send, it's going to be part of the portal and you're going to see it. But the records of an appointment, they might have the diagnosis and the medication, but not the doctor's physical findings in a patient portal record. So you can start with a patient portal if you want to, but you need to request the whole medical record. And again, that's because you have an affirmative duty. Clients with diminished capacity, there's a particular rule of professional responsibility on that. Children, we do SSI kid cases. Obviously, you're going to be dealing with the parents or grandparents in a lot of instances. So you're going to be talking to the parents. But if you have a kid that's a teenager, you ought to be talking to the kid too. And even little guys, sometimes you talk to little guys and about what's happening in the case. Other family members, a lot of our clients have difficulties. I mean, the people who are schizophrenic, a lot, they may have a mom that helps them out, or a sister, or a cousin, or somebody that actually knows where they go. You may need to talk to other people about where the medical provider is. Some of my clients will tell me they go to a doctor. Well, what's the doctor's name? Don't know. What's the doctor's address? Don't know. But I can tell you where it is. You go down 5th Street and then you turn right and it's on the right-hand side. So, if that information is enough for you to figure it out, and it may be if it's in your town. If it's not, then you might have to get family members to help you. But the client is always the primary person. The client is the person making decisions. The other people are helper people, except for obviously kid cases. The HITECH Act, this is a way you can get medical evidence without having to pay a lot of money for it. I have the citation there. It's usually just the flat rate, the $6.50, instead of in Pennsylvania the $30.08 that's in the Pennsylvania statute for what they can charge you for Social Security records. Third, CEOX isn't one of those copy services that medical providers use, like Reading Hospital uses CEOX. If I request records in Reading Hospital, CEOX is going to actually be the one that provides it. The question that's being considered right now is, does the HITECH request have to come directly from the patients, or does it not apply if the request is from the representative? And that CEOX case, CEOX versus Azar case I cite there, says it only applies if it's the individual. There's currently, HHS has a notice of proposed a rulemaking out on what rules should apply to this, in terms of does it have to come from the patient, or can it come from the rep? So that remains to be determined. A lot of providers, though, if you give them a HITECH authorization, they'll just send you the records. They might send it in an encrypted email. They might send you a box, which I always ask for electronic records, not boxes of paper. But many of them honor it anyway. Some of them don't. Some of them want to charge you, $100. They can't do that. You can keep them at least to $30. And if you use the HITECH authorization, you ought to be able to keep them to the 650. Now, 650 is the flat rate. They can calculate a thing for labor supplies and postage and so forth. But if all they're doing is pressing a button and then sending you an email with the encrypted records, then I don't even know if that costs 650. So the bigger providers will use that or charge you nothing, because it's easier to charge you nothing than charge you something that it costs more to generate the bill for 650 than it would to just do the thing.
Becky, we have a few questions.
Okay.
In terms of compliance, is it reasonable for a client to refuse opiate medication, injections, or surgery?
Well, surgery, to answer the easier question first, surgery, I think that depends on the risk benefit analysis. If it's low risk and high benefit and your client refuses it, that's going to be a problem. If it's high risk and, low benefit or uncertain benefit, like back surgery, which is, a lot of doctors recommend back surgery, but a lot of people don't benefit from back surgery, then I think it's more questionable. Opioids is, it used to be where you could look at a record and say, look, and I've done this, look, my client is clearly disabled, she takes opioids all the time. If she has a high level of pain, she's on hydrocodone all the time. Well, now with the opioid epidemic and concerns about people getting addicted to opioids, I think that's something that's changed, because a lot of providers won't provide ongoing opioids. I think if the client is going to refuse it, it's the kind of thing that they ought to be talked about with the doctor, and then the doctor can say, okay, I'm going to prescribe you this other thing, and the client takes the other thing. So if they say, I don't want to take opioids because I have a history of drug and alcohol abuse, great answer for why you don't want to take opioids, then that's fine. If you say, I don't want to take opioids despite the fact that I just had surgery, or then it ought, you want to either have it in the record already or clarify in the record, and that's part of your job, is to clarify why they're not taking opioids. Next question.
Becky, I'm just gonna, in between questions, I'm gonna quick launch the first of the CLE poll questions.
Okay.
Attorneys on the call, if you could please just respond to the question that should be on your screen now. I will leave that up for about 2 minutes. And the second question is, do all claimants have an electronic record on the ERE, or only when the case gets to a certain stage in the process?
So they just started having the ERE available at Recon. That is something that is discussed in the January forum, NOSCR forum, which is NOSCR, National Organization of Social Security Claims Representatives. So the ERE is available now at Recon level, and it's also available at the ALJ level, except if it's a paper record. I had one case where my client was actually dying of lung cancer, and it was terminal. She met the listing automatically, but her case didn't move because in COVID they weren't doing paper cases. Her case was considered a paper case only because there was a citizenship issue, whether she was an eligible alien, which she was, but it got bogged down. So some cases randomly are paper files, and those paper files are not available through the ERE. Now, why they can't all just be scanned in and made part of the ERE is a question that I don't know the answer to. But generally speaking now, it's much better than it used to be in terms of getting that availability.
Thanks, Becky. That's all we have for questions now.
Okay. Okay. I can't move my screen while your poll is up. Let me close your poll. Okay, so opinion evidence. There's two rules that apply to opinion evidence. There's the rule that applies before March 27th of 2017, which claims filed before March of 2017, which I don't think there's a whole lot of them out there now, but if there are, consult those. And then there's the rule on opinion evidence that applies to cases filed after March 27th of 2017. The factors, although these are similar, the factors that I'm listing here are similar to the ones that were in the previous rule. The previous rule talked about giving giving weight to opinions, and the new rule doesn't talk about, not allowed to give weight to opinions. So there are differences. But the factors that they consider are supportability, consistency. Supportability being if I fill out a medical source statement and I say the person that, here's the symptoms that they have, and the reason they have these symptoms is because they have um, they have MRI findings that show severe degenerative disc disease, or because they're psychotic, and despite medications they still hallucinate. And that's supportability. Like, do I explain what my opinion is? Consistency has to do with consistency with a record. I say the person would miss 4 days of work per week, or 2 days per week, or I say that they have a bunch of symptoms, and a form I indicate that says I have symptoms. Then if I look in the record, I can just, here they are. Here's the medical records that say here's all these symptoms that I just mentioned, or here's all these clinical findings. I say the doctor says that they can't, they have limited range of motion, and then you look at the exam records and you have limited range of motion all over the place. So those are the types of things that are going to make the opinions more persuasive. They say persuasive. Now you don't say weight anymore, persuasive. Relationship with the claimant. If it's a neurologist that's been treating your client, sees him every month for the past 3 years, that's going to be more impressive than a neurologist who sees him once a year. Primary care physician who sees a person all the time, and familiarity with the evidence can make a difference, because the primary care physician is one of the few people that may see all the records, the neuro records, the physical therapy records, the psych records. So if they give an opinion, they may not have the specialty, but they do have the familiarity with the other evidence. Specialization. I'm a neurologist. I'm giving an opinion about neurology. Now, I'm a neurologist and I'm talking about something that's outside my specialty, then that's not as impressive. So one of the things you can argue on appeal, if the judge finds persuasive opinions that were written by consultative examiners early on, like a year ago, is, well, yeah, they said this now, but look at all this other evidence they don't know anything about. So those are factors that they look at. So one of the things you can do to get additional evidence is to send a medical source statement. The medical source statement is going to deal with people's limitations. So the language that we use to describe whether a job is sedentary, light, medium, or heavy, those definitions are contained in SSR 8310. Occasionally means very little or up to a third of an 8-hour day. Frequently means a third to 2/3 of an 8-hour day. So light work involves frequent carrying, lifting or carrying of objects of no, I think that's 20 pounds. That's a typo. Absences, sit, stand option, all these types of things are defined in SSR 8310. If you're going to send a medical source statement, it would be better if you send it to an acceptable medical source. And this is a list of some of the acceptable medical sources. You will notice that therapist is not here. Physician's assistant is here, and that's a relatively recent addition, so that's good. So here, ooh, I went away with my wrong thing, sorry. Okay, so here's an example. This is an example of a physical medical source statement that you can send. Now, this is just an example. You can take this example and add questions or subtract questions, or, I mean, there's no magic to this. This is just a way to get the doctors to quantify it, because doctors are not usually going to talk in this language. They're not going to say, I met with, John Smith, and he has the maximum ability to lift of up to no more than a third of the day of 20 pounds. I mean, I did win an appeal because one doctor did actually do that, but that's unusual. Usually doctors don't do that. So what you want to, you send this to them to try to get them to, say, okay, the person has significant degenerative disc disease. What difference does that make? How does that affect them? So you get them to fill this out, and then you can submit that to the ALJ. You can see there's specific questions here about sitting and standing. And then in the bold here is, why do you say that? What medical findings support that? Now, it's helpful if the doctor actually fills that out. The person's list can lift less than 10 pounds, Well, that's not even sedentary. So, um, so that's helpful. You really want them to fill that out. If they don't fill that out, what you do is you argue that these, whatever the doctor said, is supported by the doctor's records, where the doctor has, findings that support whatever the doctor says here. So here's some more things that might limit a person's ability. Stoop. Stoop means bend your spine from the waist. It does not mean squat, which is actually what a lot of people think of as stooping. It's kind of a weird definition. Bilateral manual dexterity for repetitive hand finger motions. That makes a difference in sedentary work. People who are limited to sedentary work still have to use their hands for the most part. And that's in SSR 96 9P, I think. Missing work. If the doctor says they're going to miss 2 days per month, or 4 days per month, or 3 days per month, or whatever, and then the vocational expert will generally say that a person can only miss about 2 days a month. Some vocational experts will say they can only miss 1 day a month. So that makes a difference. If the doctor says they're going to miss that much because they have migraine headaches that require them to lie in bed for hours a day, they can't come to work because their pain from their impairments prevents them from doing anything, or missing work because of the pain or whatever it is. So that's going to help you. You can also do a mental medical source statement. Again, preferably from an acceptable medical source. And again, licensed psychologist is good. Therapist is not on this list. Now, it's still an other medical opinion, but it's not an acceptable medical source. So a lot of times you can get the therapist to actually fill it out, because it takes work, and then get the psychiatrist to sign it. I've seen that a lot. If the psychiatrist wants to be helpful but doesn't want to fill out a form. Only acceptable medical sources can establish that there's a medically determinable impairment. You can't be doing substantial gainful activity. And then the next thing is, do you have a medical determinable impairment, MDI? And MDI is, schizophrenia is a medically determinable impairment. Non-union of a fracture is a medically determinable impairment. Most diagnoses you can think of, chronic kidney disease or chronic kidney failure, some medically determinable impairment. Seizures, epilepsy is a medically determinable impairment. You have to have that. You can't have a person who comes into your office and says, I have all this pain. Well, why do you have this pain? Don't know. No one's ever been able to figure out why I have this pain. Well, then you're not going to get benefits because you don't have a medically determinable impairment. You need somebody to say where that pain's coming from. Maybe it's a mental impairment that your pain is coming from, but you have to have a medically determinable impairment. I had one case, actually one of the first district court cases I did when I started just doing district court cases, where the judge said, yeah, this guy has terrible, terrible problems, but I don't think he has an impairment. I don't think he has a medically determinable impairment, so I have to deny. And so I got a remand arguing that there were diagnoses in the record that said it could be caused by this, and is good enough, but it has to be something. So
Sorry, we have another question.
Okay.
So far, my limited experience is that medical providers give incomplete answers, even if the client has told the provider that the statement is coming. Any suggestions on how to get full and helpful information?
That is a very good question. So I like the client asking for their assistance. I usually send them, and if that doesn't get it back, then I send the client with it sometimes if I can't get it, because it's harder to turn down a patient when they're sitting in front of you. Here's the form, doctor, can you please fill it out? For doctors who often say, well, just let me know if I can do anything to help. Okay, here's this thing I need you to do to help. I usually send in my cover letter when I ask for it, though. I am effusive in my praise about how important, how critical, how absolutely necessary their assessment is to the success of their client's claim, and how important it is to fill it out completely. And then if you practice in a particular area, you're going to work with the same providers often. And I am effusive in my praise every time they do anything at all to help me. If the clerk who emails me the records, thank you, have a great day, this has been wonderful. I sometimes get a lower level person at a medical facility to help get the higher level person do something. I've been able to talk medical records, people who are in charge of medical records, to talk the psychiatrist into filling out the form. Like, I'll email the person who routinely sends me the record and say, it's great that you send me these records. These are so helpful, but if I could just get the doctor to fill out the form. And one of my medical records providers, and it's a relatively big practice. It's not like it's a, tiny little shop. She says, I'll go get him. I'll go get that doctor. And so she got him to fill it out. So I think you have to kind of, get to know your practices and try to impress upon them how important it is, and how you can't get the client benefits without their help, and just keep working at it. I don't think there's any magic formula, but that's what I've done. You can also send interrogatories. You can ask follow-ups. I have occasionally, I've gotten a form and the form is great. Sometimes they don't sign them, or don't put their name on them in a way that you can read it, or just don't fill it. Sometimes I've said, this form is so wonderful. Thank you so much for doing this. But if I could just get you to do number 8, if I could just get you to write a few things on number 8, that would be really helpful. And, sometimes they're willing to do that. So it's work. That's why we get, the big bucks, is all this work we do trying to get the evidence for our clients. Okay. So the reason you need to send a medical source, were there other questions before I? Okay. The reason you need to send a medical source statement, especially in mental health cases, is these are the definitions that are included, and they're used by Social Security in determining the degree of limitation. So this is useless. Because it's just like mild is defined as slightly moderate, is fair, marked is serious, extreme is not able to function. If you send a medical source statement and the doctor fills it out and says, yes, this person has moderate limitation, what the ALJ will say is, the doctor has no idea what moderate means. So I'm not giving this anyway. And I'm not going to consider this at all. The doctor doesn't know anything about what moderate is, because he doesn't know the definitions that we use in Social Security. Plus, you can't put moderate in an RFC. You can't say in an RFC, let's assume the person has moderate limitations in whatever. The guidelines to judges on how to write opinions say, or how to do cases say, don't say moderate. Don't put in your RFC, don't say moderate. That doesn't mean anything. A vocational expert can't respond to moderate. It has to be something. You have to quantify it. And the word moderate is useless. It doesn't explain anything. So what you do is you send them a medical source statement, a mental medical source statement. And I have a sample here for you. And again, this is just a sample. You can take out parts you don't like. You can add other parts. This is just a one sample of how to do this. So we haven't really talked about the listing of impairments. Kristen did yesterday. And let me just review that for a second. So third step of the sequential analysis is, do you meet a listing in the listing of impairments? Social Security has a list. And this is how I explain it to clients too. Social Security has a list. If you have a disease on the list, exactly the way it is on the list, then you can get disability benefits. It's a limited list. So lots of impairments, lots of things aren't on it. But if you do happen to have the fortune to have an impairment that's on the list with every single thing that's required on the list, then you can get disability benefits. So for mental health listings, there's an A criteria, which is the diagnosis criteria. So for example, for 1204, which is depression, it'll say, depression with, I forget how many it is, 5 of the following symptoms, including things like suicidal thoughts and decreased concentration, that kind of thing. So all of the mental health listings, which are in 12.00 with a listing of impairments, have an A criteria. So the A criteria is basically, do you have this thing? And for the most part, they are the same as what's in the DSM-5, which is the Diagnostic and Statistical Manual, 5th edition, which is what mental providers use to determine what do you have. Like I come in and I say I cry all the time and I can't sleep. What is that? I hear things, I see things. So the doctor will come up with something. You have schizoaffective disorder, or you have whatever it is. So the A criteria is the how you figure out what it is. For Social Security, then the B criteria are the things that talk about how that affects you. So understanding, remembering, interacting with others. Like, so you're schizophrenic. Well, what does that do to you? Well, that means, or I'm paranoid. So I'm paranoid. So whenever I see anybody, I think they're trying to kill me, and I run away, or I attack them, or I hide behind a tree. I had a client once who had difficulty getting into his mental health treatment because he was afraid of demons, and the demons came out especially in the cold. So in the cold, he was afraid to go out of the house because the demons were more active during when it was cold. So he would often make it to the provider's place and then hide behind a tree because he saw demons, and then he would go home. And so it was sad. But so the B criteria are how it affects you. So, well, let me just mention a bit about drug DAA, drug and alcohol. What is it? Drug and alcohol. Anyway, substance abuse disorders is DAA. So you can't have a substance abuse disorder all by itself that'll give you disability benefits. You used to be able to. In fact, I have did cases way back when where I argued that my client was eligible for disability benefits because he was an alcoholic and he would drink until once he stopped drinking, the only thing would stop the drinking was if he passed out or went to jail. And we got him benefits because you used to be able to get benefits because of that. Now you can't get a disability benefits based on a substance disorder if that's the only disorder you have. And you also can't just get disability benefits based on a substance abuse disorder if it's material. So they figure out if it's material by looking at would the impairments, if we just magically took out the substance abuse, would you still have impairments that were disabling? So if we took out the substance abuse and you're not, what's left would not be disabling, then you're not entitled to benefits. So now I have a confusing sentence here, which is if there's no evidence of mental health, MH, that it would be disabling in the absence of substance abuse, then there's no denial. So what that means, and they have a little section here in SSR 13.2p that talks about how connected substance abuse is with mental health. So like a lot of people, they have mental health problems, and so they start drinking as a way to deal with their mental health problems. And maybe they never stop drinking. Like maybe there's not a period of abstinence. This is one of the things you can look at. You can say, well, look, they were abstinent for 9 months and they were still hearing voices, or they were still whatever. They were still having their symptoms. They were still paranoid. But if you don't have that, if you have somebody who's, constantly, using and also has a history of, suicide attempts and has been in the hospital, Social Security can't deny your case if there's nothing that says they wouldn't be disabled if they stopped using drugs or alcohol. So they can't deny. And that's because Social Security recognizes that if people are still drinking and still have mental health disorders, that nobody in this world, no matter how educated and how much experience, can accurately predict what would happen if somebody who's schizophrenic and also drinks stops drinking. How much of the schizophrenia would be left? Would they stop having hallucinations? We do not know. They can't deny under those circumstances. A lot of judges do not understand this rule at all. They do the analysis wrong. You're supposed to analyze it first, taking into account all the disorders, including substance abuse, and then take out the substance abuse and analyze it again. A lot of times they don't do that. Is there a question about that? Okay. Here's an example of a medical source statement. Same types of the frequency and length of contact. That's because of the factors that we take into account when we look at opinion evidence. Diagnosis, again, that's the A criteria. Treatment and response. So doctors will write You know, I've given them medicine and they're a whole lot better. Or despite heavy duty, you know, despite Depakote, despite Seroquel, despite bunch of medicines, they're still hallucinating or they're still depressed, or, you know, so they might say limited response, or you know, whatever they'll say here makes a difference. Like, just, you know, everything they're doing isn't working. Clinical findings on mental status exams, you want to see things like um, pressured speech, depressed mood, uh, seems to be responding to internal stimuli, something that the doctor actually sees on mental status examination. Now, the problem a lot of times now is that the psychiatrist does a 15-minute med check. In the 15-minute med check, a lot of times they just don't see enough. They don't talk to the client very long. So those mental status exam findings can often not be that helpful. So that's a problem. And then you look at the therapy records, and the therapy records are much more impressive, which is why it's important to get therapy records to give context to the mental status exam findings. The psychiatrists, all they're trying to do is, do I need to figure out, do I need to increase your Risperdal? Do I need to give you a new medicine? And if you come in and say, it's, you know, what the medicine I'm taking, I don't really have any side effects and it's okay, I don't feel any, you know, whatever, I don't, then that's all they're doing. And now in COVID, they're not even seeing people. I mean, they're doing telemedicine for the most part. Prognosis, you know, if you're doing disability work, you always get cheerful when you see negative things. So if the prognosis is poor, so yay, that helps my case. Doesn't help my client, but it helps my case. Pain can often make a difference in if a person, the person's perception of pain is often affected by their psychiatric condition. People, like I said, the early example, somebody comes in, and a lot of people come in and say, I'm disabled because I have back pain. Well, your perception of your pain may be influenced by the fact that you're depressed. You've probably seen those commercials. Depression hurts. It does. People who are depressed feel bad. They don't just feel, I mean, they have depression symptoms, like they're overwhelmed and they can't concentrate and they feel like killing themselves. But a lot of times they also feel like they're in pain, physically in pain. Like my back hurts, my shoulder hurts. I just feel like I feel bad. If that's the case, then you're asking the doctor to explain that, because judges are required to consider the combination of impairments. We act like in this country and the way we do medicine, mental health is in this one big box that, you know, like is encased in concrete, and then physical impairments are in this other big box encased in concrete. But that's not how people actually experience symptoms. They're all connected. Okay, so here's a list of signs and symptoms. This is just a list, which is not a complete list, because a complete list would be too long, and even this is too long, really. A list of symptoms, signs and symptoms from the A criteria of the listing of impairments. All of the A criteria. Well, not all of them, but a lot of the A criteria. Like I didn't put in the IQ thing. If you have somebody with an IQ that's 1205, you need to add a question to your medical source statement. So so signs, there's a difference between signs and symptoms. A sign is something you can clinically observe, like pressured speech. That's a sign. A symptom is something that the client experiences, something that they can tell you about, but you can't see. The good ones in terms of trying to prove your case are the signs, the ones that the doctor or the, you know, clinician can see. So anyway, you ask them to check off which ones they have, because these are what you need to make an argument in terms of a listing. But these are also things that will be helpful in improving your client's inability to perform any kind of work. Okay. So you can make this list shorter if you know that some of these aren't on here. It's surprised to me sometimes when I ask doctors to fill these out, or other clinicians, and they check symptoms that I am not aware of and do not appear in their records, which might warrant some follow-up from you. Like if they say that the person has issues that haven't been identified previously. Okay. So then I asked them to give more information about the ones that they've checked. So you want to see what causes it, what makes it worse, how long does it last, has it changed over time. If the doctor writes something here, that's helpful. If the doctor writes, I've been treating her for 4 years and her symptoms just continue to worsen despite all treatment modalities that we've tried, that's helpful. So this is the scale for determining how things happen. Remember, I told you that moderate is useless in terms of quantifying something. So this is a scale that quantifies a limitation. So seriously limited means 10, 11 to 20%. Seriously limited, if you say, you ask the doctor that, you define this, and then when you have a vocational expert in front of you, you say, what impact on the person's ability to perform in the competitive work would there be from serious limitation defined as 11 to 20% of the day and then you give the example of the limitation, and then unable to meet competitive standards 21 to 40%. Again, this is not a magic scale. This is a scale that just quantifies it in a way that you can turn it into something that's vocationally relevant. Saying that somebody has marked impairment, which means serious, it doesn't mean anything. And you can't, if you ask this to a vocational expert, the just say moderate or marked, the judge will likely say you can't ask that. And you see this has to do with regular and continuing basis, 8 hours a week, 5 days a week, 8 hours a day, 5 days a week, because that's what we're looking at. Can somebody do something 8 hours a day, 5 days a week? Which is something I have to explain to the client sometimes, because they'll say, yeah, I could do that. Okay, but could you do it every day, day after day? So here's the list. This comes from the B criteria. So if somebody can't understand, remember, and carry out very short and simple instructions, they basically can't do anything. If they're unable to meet competitive standards, they're not, there's no jobs out there for them, is what a vocational expert is likely to say. Detail doesn't really matter, because if you can do short and simple, then there's work out there for you. So, you could maybe eliminate that. There's social limitations here. So these social limitations are actually limitations that are often very difficult for our clients. So you want to not only ask the doctor this, but also develop evidence related to this. So if you say they can't, they're unable to meet competitive standards with respect to suggestions, criticisms, and correction from supervisors, you're going to want to ask your client about that and give me examples. So what happened the day that you were fired? What happened? Why were you fired? Well, he told me to put the boxes on the shelf, and I told him I don't think the boxes should be on that shelf. I think they should be on the bottom shelf. They've always been on the bottom shelf. I don't want to put them on the top shelf. And the boss says, well, I've decided I want them on the top shelf. And then you just start cursing at the supervisor and tell him that he doesn't know how to do anything, and you've always done it this way, and you're fired. Well, that's an example of somebody who's not, who's socially is unable to respond appropriately to supervision. And then there's questions about consistent pace. Any job, there's not every job has like factory quotas, you have to finish 100 things, but every job has expectations about the pace at which you do things. And you can, if you ask a vocational expert, they will say that every job has, you're expected to do a certain amount of things in the job. So,
Becky, we
okay.
have a question. As advocates, do we have to choose between whether to provide the doctor a medical source statement or an RFC report to complete, or can the doctor complete both?
Well, they can complete both, but usually the specialty of the doctor is going to determine which one you send them. You're going to send the orthopedist the RFC for, light sedentary, and you're going to send the psychiatrist the mental one. If you don't have a psychiatrist and all you have is a PCP who's prescribing the psychotropic medications, you might send them both. It really depends on what the doctor is or other provider is treating the person for. So I think you just have to evaluate your evidence and decide which is the best person to send it to. So anyway, you want to have explanations here too. This has to do with stress tolerance questions. A lot of times people, if they didn't have to work at a particular pace, if they didn't have to work with other people, maybe they'd be okay. There's very few jobs where there's no interaction. Vocational experts will say things like, wow, they could be a janitor where they work at night and nobody talks to them. Um, but they're still going to have expectations about their work. And there's some nice language in SSR 8515 about people who have serious mental health problems, even knowing that their work is being supervised makes them nervous. Like they worry about whether the person will come by and say, oh, you obviously screwed this up. Here's the absence questions again. This is a duration requirement. Impairments last or expected to last at least 12 months. That's the duration requirement. And you can't get to, in order to get disability benefits, you have to prove that the person has an impairment that has lasted or can be expected to last for at least 12 months. So then the question is, are COVID people with COVID going to be eligible for this? And we just don't know yet because we don't know how long things are going to last. Here's a sample question for drug and alcohol. Remember I said that if there's no evidence of what would happen, you can solicit an opinion about what would happen if your client stopped drinking or using drugs. And if the doctor says it wouldn't matter if they stopped using drugs, he would still be schizophrenic, or it wouldn't matter if he stopped using drugs. A better example might be a client who has, like my client, I have a client with dementia brought on by excessive alcohol and cocaine use. She does not use alcohol or cocaine anymore, but she has memory loss and she's unsteady. So she has alcoholic dementia. Would be an example of, it doesn't matter if she wasn't already abstinent, which she is. But you have to keep in mind, if the doctor fills this out and says if they stopped using drugs, they would be perfectly fine, you have to send that in. So you want to be careful who you send that to. That's why I pulled that out as a sample. So the all evidence rule, as I just mentioned, you send out medical source statements, but you only send them out to providers who you think are going to be helpful. So the provider who has in his progress notes, I don't think this person is disabled at all. I think this person is a malingerer. I think I think if this person would just put their mind to it, they would be able to work. That's not the person you send a medical source statement to. You send a medical source statement to the doctor who says, I feel really bad for this person and I wish there was something more I could do to help. I've advised her to apply for disability benefits. Or they filled out a form for welfare saying they're disabled, although even that's not a guarantee they're going to be helpful. So you want to make sure that whoever you're sending it to is somebody who's likely to be helpful, because if you get it and it's not helpful, you are stuck with it. That also applies to records. So unlike in a custody case where you would be, you might see some evidence that the client that you become aware of that you think, well, boy, that doesn't help. You're not going to submit the text messages of your clients cursing and yelling and threatening somebody else. But in a Social Security case, anything that all the evidence that's relevant to whether or not the person is disabled, you have to submit it, whether it's good or bad. So that's the all evidence rule. So you have to be careful in sending medical source statements that you don't generate bad evidence, because once you've generated it, you're stuck with it. And that's the standard there in the reg. So how do you submit it? You submit it using the ERE if it's available, or barcode if you can't. ERE, definitely preferable. This is a barcode. Now, this is a barcode for, you can see the document description, medical evidence of record. There are other barcodes that might be sprinkled about through the file. If they send the client a form saying, are they going to come to the hearing? That form will also have a barcode, but that barcode will be put in a different part of the record. So you want the big barcode that looks like this. It's a whole page, covers a whole page, and that's what you can use. If you're going to submit using a barcode, you barcode on top, evidence on the bottom, so that it goes right where it ought to go. But don't do it this is a last resort. This is when you apply to use the ERE and they screw it all up and you can't get things in the ERE, or you sent your 1696 and they still can't manage to get it in the record so that you can submit evidence. You know, you use the barcode as your backup. So you want to have it. You don't want to throw it away. You want to make sure you have it because that's what you can use if you don't have anything else. But you don't want to use the barcode if you can avoid it. What you want to do is submit it through the ERE. You can sign up to the ERE through ssa.gov/AR. They give you instructions right there for how to do it. It usually takes months. So if you think you're going to start doing Social Security work, you probably ought to do this right now because it takes a while. The person, well, this is recorded, I won't. So just expect that it might take a while to get it right. So, you know, do that in advance. And then once you've done it, you submit the evidence electronically. You can submit it from your file. So ideally what you want to have is a system where you send your requests for records using the high-tech authorization and whatever other authorization. You send the high-tech authorization and a general authorization. A lot of the big providers have their own authorization form. You want to get that, and you can usually get that right off their website. So Reading Hospital, they have their own. Penn State Hershey, they have their own. So use their form, because it very well may get kicked back if you don't use their form as opposed to your form. And then use a general authorization form for anybody like small providers that don't have their own. So you do the high tech and a general authorization to get the records. So anyway, you've done that, you've gotten your records, they send them back to you electronically, you've organized them in your file, and then you just send them right from your file in your computer to the ERE, and you never have to print out a piece of paper, which is ideal because, as I said, it's not at all uncommon for records to be 3,000 pages long now. And that's partly because of electronic medical records. They say things over and over again. It's the way it's printed out or the way it's stored. It just generates a lot more pieces of paper than it used to. You need to not put numbers, punctuation, or special characters in your file names, and they will tell you that if you try to submit it with that information, they'll kick it back and they'll say you can't do it. So you can't, like, you might have the file, you might have your file name labeled Dr. Smith neurology. You can't put a period after doctor. So just don't. You might have it physical therapy, or the name of a place. If it has an apostrophe in it, take out the apostrophe so you can submit it. And you need to, as you're figuring out what you're going to submit, make sure you know when it starts and when it ends, because you're going to have to put that in when it starts and when it ends. And then you'll get an immediate electronic receipt, which will help you know what you've submitted and not submitted, and will help you prove to them that you did submit it when they say that you didn't. Okay, so I'm going to run through how to do this. I would normally say how many people use the ERE, but since I can't see you all, you go to the screen, the ERE, ssa.gov/AR, and then you enter the ERE, press enter, the ERE. Then you either go to client's electronic folder, or pick up files, or get status reports. So you can select one of those. You're going to access the client's electronic folder if what you're going to do is submit your electronic evidence, or you just want to look at it for whatever reason. If you've asked them, if you've downloaded what's already in the file, then they'll send you an email and say, well, it's ready to pick up the whole file. And you can select whatever you want in the file, and then you hit pick up files, and then you can go there and pick it up. So it's a double, the security requires you to enter a one-time password that they send to your cell phone. So you have to have a cell phone that you give them. It's my personal cell phone. Some people have work cell phones that they use, but they'll send you a one-time password that you enter in. Then you agree to all these things. Put your client's social security number in at the bottom. Click I agree. And then you're in the folder. If you want to upload a file, well, if you want to download, you want to see what they already have, it's already in the file, you can select download, select it to PDF, and then you select what you want. If you go to case documents, you'll get everything. If you go to exhibits, you'll only get what's exhibited. Case documents has more than exhibits. Case documents has like things like report of contact that might say the representative called me and said the address has been changed, or I tried to do something, or just evidence, things that are how the case was worked up, that are not going to be exhibits in the formal exhibit file. So if you're, you want to make sure that you know everything there is to know about the case, you can go to case documents. Right before the hearing, I want to make sure I do the exhibit list, so that I can refer to things by exhibit, because that's what the judges would prefer. Like it's 3F, page 2. Or if you're submitting evidence, you want to upload a new file, so you click upload, and then you click choose a file, and then it will ask you what the document type is. Medical evidence is going to be medical evidence of record, but there's also appointment of representative, withdrawal, education records, work history, list of medications. So, just read the list and decide what you need. You can add notes. Sometimes my notes are part 1 of 4, because it's so voluminous that I can't submit it all at once. I'm doing it, 50 pages at a time. And then click add another file. You can do 5, I think. Yeah. And well, if you only had 1, you hit submit. You can add another file and just add as many as you need. And if you reach the maximum in terms of how big it is or how many you've submitted, then you can just submit all the ones you have, and then just go back in and submit a bunch more. So this is what you chose: a file. This is an example of my file name was Lower Bucks Hospital, and then medical evidence of record, the treatment source, the dates, and then you just keep going. And then you will get proof that you sent it. And what I usually do with these, and it says here what it was, I usually print it as a PDF and put it in my computer file, but I also I try not to print very much in terms of pieces of paper, but I print the piece of paper and I clip it to the left-hand side of my hearing file. And then every time I submit something, I add to that pile. And then later on, I will add exhibit numbers to it to make sure that everything I submitted is in. You also do that by looking at the exhibit list, but it's kind of a quick way to check back to make sure that everything you submitted is where it ought to be. So you want to keep, yes.
Sorry, we have a question.
Okay.
Given the volume of obligations and tasks to be accomplished to represent a claimant competently, is there a stage in the claim where you are less likely to offer representation? For instance, hearing already scheduled. Thanks and good job, Becky and Kelly.
Well, thank you. Yes. Once the hearing has already, now I have done them once the hearing has already been scheduled. I just did a kid case where the hearing was already scheduled and there was a month to go, but I thought it was a really good case, and the grandma was Spanish speaking and she needed help, and I just jumped in and did it that quick. I would say, you're going to have to just decide based on your workload, on your discussion with the client. Taking a case, we normally get 75 days notice. I think 75 days is enough. But if the hearing's already been scheduled and it's less than a month, I don't think I'd ever take it with less than a month. I'm never say never, but less, because it takes 2 weeks to get medical records as a general thing. So to try to get medical records. So what I would say to a client in that instance, if it's close, I would say, go to the hearing, tell them you want an attorney, you tried to get an attorney, you haven't been able to get one, ask to have it postponed. And then they come back to you. Now, don't tell them to say, MidPenn said they would represent me, or MidPenn is representing me, which is what they often say. MidPenn's representing me, but they're not here. Now, don't, go and say, nobody's representing me. I can't get somebody to represent me, but I want to, and I want to get the hearing postponed. You can do that. So otherwise, it depends on the case. Social Security is going quick, than it has in the past in some of these cases. So, you know, you kind of have to do it based on your caseload, but that's a good question. So I gave you I gave you a bunch of materials because I'm a big fan in samples, big fan of samples. I think it's easier to know what you're doing if you have a bunch of samples on how it's been done rather than try to make it up out of whole cloth yourself. So one of the samples I gave you is a tracking form. It's an Excel spreadsheet where you just put the name and the address of the provider and did you send it by fax? Did you send it by email? When did you send it? And then when did you get it? And then if you didn't get it, what did you do by way of follow up to try to get it? And that's the document then you can use for your efforts letter when you say, I requested it on this date. I requested it again on this date. I called the office 3 times on this day and then every day after that, but I still didn't get it. And that's why I need you to keep the record open for me to get it because they promised that they would give it to me. And then the date you submitted it to the ERE. And I talked about keeping proof that it's there. And then, you know, the date that you looked at the file and you saw it is in the ERE because it might not be. You know, you want to make sure that it's actually there. So sometimes what you do at the beginning of the opening of your hearing is you say, I submitted it, but it's not there. You can use a spreadsheet like I've given you an example. You don't have to. You can use a list, but you need to have something. Don't just have, you know, files thrown all around. These are my suggestions for reviewing the evidence. Type your notes, put the exhibit numbers, put the dates when you're reviewing evidence, use a consistent format. Make sure you list objective findings because we know when we talked about records, that's what, or opinion evidence, and just generally deciding the case, that's what they're interested in. You can look at the Mayo Clinic, I found is really good for explanations of impairments. CDC.gov has information too. So the efforts letter, we've talked about that. You need to send an efforts letter. You need to send it. The drop dead deadline is 5 business days in advance, not including federal holidays, but you ought to send it more than 5 days in advance. You send it more than 5 days in advance, and then you do it. Then you do an update 5 days in advance and say, here's everything I've done. Here's what I didn't get for whatever reason. So I think we've talked about that a lot already. This is an example of a letter that I wrote that I used then to explain the records I tried to get from Puerto Rico, which I have to tell you is just about impossible. But but I tried to get these special education records from Puerto Rico for one of my clients, and this is what I wrote for what I tried to do to get that. So that would be a basis for, you know, asking for a subpoena or just explaining why you don't have it, so the judge doesn't blame you for not having it. So you don't get into an opinion and says, well, you know, I looked at the record, but they don't even have these special education records, so obviously they don't really care. Here's the sequential analysis that if you went to Kristen's really good session on Tuesday, you would already have heard this discussion. But is there SGA? Do they have a severe impairment? Severe impairment is a de minimis standard. It's not a high threshold. But notice severe is a term of art. Severe impairment means second step. So when you're making arguments, don't say this is a severe impairment because blah, 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 blah. When you're talking about RFC, you don't want to use that word because, like I said, it's a term of art. Third step, listing of impairments. Fourth step, can they do their past work? Or does the grid apply? The grid is just medical vocational guidelines that, so if you're 50 and you're sedentary and your prior work is, or you're 55 and you're sedentary and your prior work is unskilled, you get disability benefits. The older you are, the more likely it is you'll get disability benefits. And the grid is in the regs. It's Appendix 2. So it's usually, if I'm going to the regs themselves rather than any kind of list, I go to 404 1599, and it's Appendix 1 is the listing of impairments. Appendix 2 is the grid, and you can look at the grid. And we'll talk more about this in future trainings. And then can they do other work in the significant other work in the national economy? So that's the 5-step analysis that you'll be explaining to your client in words that they can understand. Sources of law. So SSA.gov has a lot, but keep in mind that SSA.gov is not always updated. So right now, I think the last time I checked, SSA.gov, the regulations have been updated as of maybe April 2020. Anyway, not yesterday. So they used to be better about this. So you need to go to Lexis Westlaw to make sure that you're actually using the correct regulation, or before you write a brief, or when you write a brief. You can also look, that's where the SSA.gov, where the regulations are, where the Social Security rulings are, where POMS is. And the SSI, for kid cases, the rules are different. And this is where they are. And we're going to do a separate section just on that. So you can sign up for that, and that would be very helpful. The rulings, Social Security rulings, here's a sample. I talked about duration, lasted 12 months or expected to last 12 months. Medical impairments that are not severe, that's where you can look to see what your argument can be there. Assessing RFC 96-8P, that's the language there is about on a regular and continuing basis, 8 hours a day, 5 days a week. I often cite that. 96-9P has things like what difference does having a cane make? Do you need to stoop? 11-1P, the subsequent applications. The general idea is they don't want you to do subsequent applications because it's too confusing. The established onset date, your client may say, I was disabled as of the year 2000. Well, it's 2020 now, so the likelihood you're going to go back that far is very remote, unless maybe it's an IQ and you became, your IQ was 55 when you were a kid and it's 55 now. So evaluation of young adult cases, 11-2P has specific rules, 16-3P is symptoms. There are disease specific SSRs. Fibromyalgia, chronic fatigue syndrome, those are tough cases to do. Cases that have a substance abuse issue, also tough cases to do. So you want to look at the guidance that they provide on that. And then there's specific ones. Obesity, they keep changing this. This is like the third or fourth, or it's ridiculous how many different SSRs they've done on obesity. Primary headache disorder is a relatively new one that you want to look at if you have a client with chronic headaches. 8310 is where the rules on sedentary light are. 8515 we've talked about. Failure to follow prescribed treatment we've talked about. HALEX is in SSA.gov. HALEX is what the ALJs and Appeals Council use to decide cases. There are rules in HALEX about the efforts letter, the 5-day business rule, late filing. If you're arguing to the Appeals Council and you can cite a HALEX provision that the ALJ violated, you're likely to, that's a pretty good argument. And we're also later going to do more about appeals. So in this series, well, not the series in February, but after that, I think we're going to do more on appeals. But good place to look. And a good place to look, like, do I want to request a subpoena? Go look in HALEX. It'll tell you what you have to do 20 days in advance. So don't wait till the last minute if you're going to ask for a subpoena. 20 days in advance of the hearing. POMS.
Becky,
yes.
Sorry, if you don't mind, I'm going to launch the second of the CLE question poll boxes. So attorneys that are requesting CLE credit for your participation today, please respond now. I will leave it up about 2 minutes.
Okay.
Thanks.
POMS is the Program Operations Manual System, which is what the SSA employees use to process claims. And it has all kinds of helpful information, like what SJA is for the calendar year. DI stands for disability insurance. There's one on evaluating medical opinion evidence, which are the factors we already talked about. So you can find it there too. Dictionary of occupational titles. At the hearing, the vocational expert will give you a dictionary of occupational titles number. Here's an example for cleaner. The GOE in the Dictionary of Occupational Titles refers to the selected characteristics of occupations, which is the companion publication, and they have definitions. They'll have strength, reasoning level, SVP, specific vocational preparation, which is how long it takes to learn the job. Some of these occupations are obsolete. You can ask about that at the hearing. You can ask the vocational expert, so is that the job? Does that clerk typist job, does that even exist in the world anymore? Only politer than that, but that's that's the question. ONET is actually where the jobs that exist in the real world are. If you go to selected the SEO, you will find more information about particular jobs, like that. For example, the house cleaning job, the strength here is light, I've highlighted. Handling is frequent. So you can argue, well, my client can't do frequent because of manipulative or strength limitations. There's an example of what it looks like. It's kind of hard to read. And both of these are ancient. The Dictionary of Occupational Titles and the SEO, both ancient. Social Security keeps talking about updating that, but it hasn't happened yet. If you're going to write a pre-hearing brief, use regs, SSRs, and HALEX. Do not use POMs because that's not what they rely on. And do not use case law. They are specifically prohibited from considering case law. If you're going to talk about evidence, you want to focus on the good objective evidence you have, MRIs. You can mention pain, but that shouldn't be the focus of that shouldn't be the focus. You want to hammer in the good objective evidence. Don't want the judge to miss that. I do a specific citation to exhibit and page number. You don't want to make it long. You ought to look at samples other people have done. Now, gave you a ton of materials, but not that. But I can give Kelly a sample trial briefs to send out. You want to spell out the theory of the case either in your brief or at the hearing. They meet or equal listing. A grid rule applies, or they're unable to sustain work due to the combination of their impairments. But you ought to have a theory. This is not a time when you just show up and the judge says, okay, we're going to do it. Let's start. You need to have a theory of your case. It needs to be relative. You don't want to spend all of your maybe 45 minutes you get for the hearing arguing, which is why it's helpful to file a brief in advance. But you ought to know your argument, and you ought to know whether each piece of evidence is that you're referencing. So if you're referencing an EMG, you need to know where it is. If you've got an MRI, you need to know where it is. And you also need to be prepared to respond to questions that the judge has, like, where is that MRI? Is that the first MRI? Is that the only MRI? This is an example of a medical source statement argument. Now, after this is the first paragraph. The second paragraph would be, and this is consistent with the evidence because, and then I would cite all the evidence that shows depressed mood, diminished interest, sleep disturbance, decreased energy, difficulty concentrating, thoughts of suicide. So it wouldn't be just this. This is just the beginning of an argument. You want to cite specific, yes.
Sorry, we have a question and I'm hoping you know what this means. Is nut sorter obsolete?
I don't know if that's obsolete. Now, I do know that people still sort things at Nouse Food in Adams County. They still sort apples by hand, but I don't know if nut sorter. I can't tell you that off the top of my head. I haven't looked that up in ONET. But that certainly is a good question to ask the vocational expert if you get that answer. Is nut sorter, is it, what's the basis for you saying that nut sorter is a job that people can do now? Good question. Surveillance system monitor too. I mean, that is not, a lot of jobs that they identify are not jobs in the real world. So when you're looking at your evidence, again, you want to do typed notes, not stickies on printed copies of evidence, because the print, you're going to have 1,000 pages. In the average case now is 1,000 pages. Print stickies is just not going to cut it anymore. You want to look for all that objective evidence so you can point to it. Your opening and closing is going to be your theory, again, your theory of the case, age, education, and work background. You want to amend the onset date if that's appropriate, and make sure that you don't amend it after the date last insured, because if you amend the onset date to after the date last insured, we have to question whether or not that's competent representation. Because if you amend it to after the date last insured, which is in Title II, you have to become disabled by a certain date or you don't get Title II benefits, the disability insurance benefits based on your earnings record. If you agree to amend the onset date to after that date, that means forever, likely forever, but forever, certainly for this case, they do not get Title II benefits, and they're unlikely to get more quarters of coverage if they're getting even if you get them SSI. So you ought to have date last insured, like put that someplace where you can see it at the top of your hearing, your notes on what your questions are going to be, and your theory of the case. You make sure you talk to your client about that. You do not want to make a mistake and amend to after the date last insured. And here's another example of theory of the case type arguments. Hearing questions, you check off what the judge already asked and you ask what they didn't. So again, age, education, work background, lift, carry, walk, stand, how long, how much can you lift, how long does it take, or not, how far can you walk, how long can you stand, what happens if after you stand for 10 minutes, you know, my back hurts so much I have to sit down. Do you use assistive devices, a cane, a walker? Pain descriptions, what causes it, what do you do to relieve it, how long does it last, side effects of medication. Doesn't make any difference unless it's verified in the record, but if it is verified in the record, like I take this medicine for pain and it makes me drowsy, that's something that's important to describe. Duration of symptoms, this has been going on for a year, this just started last week, this has been going on and off, it's getting worse, it's getting better. Be prepared to respond to questions the ALJ may ask you. Again, what's the MRI? Just specific questions about your case. Some judges will treat this like it's an argument court. And then some judges will treat it like it's an argument court. And then they'll say, okay, well, you amend the onset date to this date and I'll grant benefits. Well, they don't say exactly that, but they clearly mean that. So you need to know your case cold so that you can respond to that kind of thing. Here's some sample questions for the client. Now I gave you 2 sample transcripts in the materials, one just mental health and one mental health and physical. So you can kind of see how the how a hearing goes. I would say the only comment I have on the argument at the end of one of the transcripts is when you make your argument, don't say I believe or I think, just say it. They meet the listings. They can't work because they can't sustain it, whatever. You don't need to say, you shouldn't say I think or I believe. But good examples, especially of asking questions about mental health impairments, because sometimes it's hard to quantify those kinds of things. Okay. Vocational expert testimony, we're going to have a whole week on this. So it's up here, but we're going to spend a week on this. So I hope you can all come to that training. I know you will learn a lot. We're going to do some breakout sessions so that, you know, people can practice. So participate in that. I will just say now that the hypotheticals have to include all the impairments supported by the record. So for questions, ssa.gov, NOSCR forum, plan has a listserv. Kelly mentioned these materials are going to be put up on plan so you can see them. And I'm at MidPenn Legal Services. You can contact me if you want to. It's Dempsey at midpennlegalservices.org. Yeah. So any other final question?
We don't have any currently waiting, but for attendees, if anybody has any other questions you'd like to type in the chat or comments, please do so now.
Right, because it's 4 o'clock and I thought I would not be able to talk for 2 hours, but I am I am pleased that I have some voice left. So I'm glad you participated.
We have a question here, Becky.
Okay.
What is the, oops, everyone's writing thank you and they're
okay. Thank you.
The question is, here we go. Oops, it keeps moving on me. What is the disclosure language that you use when you suggest that someone get treatment?
Just exactly that I suggested that my client get treatment for her impairments. It can be that simple. If I suggested something more specific than that, I could do that. Let me, before I forget, correct my email. I think I said MPLS, but it's actually midpenn.org or Dempsey at midpenn.org. So yeah, so it's not, I think it can be a fairly general thing. You don't have to say everything, but I've suggested they get, like I had a client who came in to me and said she had schizoaffective disorder and was currently having hallucinations and she wasn't getting any treatment. And I told her she needed to get treatment both for herself and for her case. And then in the letter that I wrote to Social Security, I said that when she came to me initially, I suggested that she obtain treatment for her impairments. And that was it. Okay. Well, thank you all for participating. I hope that you will join us in the rest of our trainings. They're Tuesday and Thursday through the month of February. We have lots of great stuff coming. And then we hope to have even more in the future. So feel free to email me or give me a call at MidPen. Again, rdempsey at midpen.org. And it was great. So thank you.
Thank you so much, Becky. This was very helpful. Very good questions. And we have 2 more sessions in the series of DAP, SSI, SSDI trainings next Thursday afternoon and next Tuesday afternoon. And materials will be sent out. So thanks, everyone. Have a good rest of the day.